All right, ladies and gentlemen, call to order for the October 9th, 2024 meeting of the Board of Adjustment. Ron, do we have a quorum present?
Yes, sir.
Thank you. Okay, the meeting is therefore declared open, and let's start with the Pledge of Allegiance to the United States of America. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Let me call on the people on the committee. Are there any amendments that are needed to the agenda as it came to you? If not, then do I have a motion to approve the agenda?
I'll move to
Bill,
approve.
thank you. Any second? Thank you, Bruce. All those in favor say aye.
Aye.
Aye. Okay, let's go forward. The minutes to our prior meeting on September 11th were 23 pages long, and as Bill can attest, I was likely to find a typographical error or two in them. Kim is in the process of resolving that, and so I don't believe that we can pursue approval right now. He will send out a revision once it's all done. And Lisa, can you confirm that if the minutes are sent out in revised form, that each of us can respond separately approving them, and that will be effective?
No.
No. Okay. So we're actually going to have to get together at a meeting?
Mm-hmm.
Okay. Well, we got more meetings coming up, so that's fine. Well, thank you. So I guess we basically table this. Let's just put a U in minutes, by the way. I'm sorry I missed that. But we'll table that and we'll move on to new business. So we had two variances that were considered at the prior meeting. The first one was VAR 2024-01, and that is the issue of the variance for a pool. Ron has put together a statement of findings of fact. And Ron, do you want to say anything else about that before we consider it?
Sure. The process that I went through, majority of the facts were already included in your case summary from last month. What I did from there was I went back and listened to the meeting and introduced any evidence that I felt like were relevant to your decision and just evidence in general. And you'll see those, such as during the hearing, Mr. Elliott testified. Those were the ones that were added.
Right.
It was reviewed. We looked for some, to make sure everything was okay. I do think you had a couple of changes, Mr. Chairman, and those have been addressed, the ones that you have pointed out. I think there was one change.
Yep.
The conclusion, it said initially, based upon the foregoing findings of fact, the board concludes that the applicant is entitled, and the word not was, that was just my oversight. I apologize for that. It's what happens when you work with a template sometimes.
Oh, that's no worries. So everybody on the board here has had an opportunity to review this, and I believe that Robert's Rules of Orders are going to suggest that we'll need a motion to approve these in a second. We'll then discuss and vote. And my question to you, Ron, is the date that we'll put on here when these are approved, if they are approved?
Today's date. Yes, sir.
Okay.
I would move to approve the one for the variance 2024-01. With that word not in there now, it seems to be correct.
Thank you. Bruce, second. Thank you, Bruce. Okay, any further discussion? Once again, I appreciate the job that Ron did pulling all this together. If there's no other discussion, all those in favor of approving and executing this order, please connote by saying aye.
Aye.
Any opposed? Okay. Thank you. That motion carries, and it is ordered this 9th day of October, 2024. I am signing it as the chairperson, and I guess you're the effective secretary? Okay, thank you.
Before moving, on, what we'll do from here is we'll make sure that, and Mr. Elliott's here, we'll make sure he gets a copy, as well as, I guess with Mr. Amenta, you were actually the applicant, so we'll just make, and the property owner, so we'll make sure that you get a copy of the written notice of the decision they just voted on. That's okay. I can give you a hard copy, unsigned at the moment, if you wanted to look at it. Okay, she's gonna, thank you, Lisa.
Okay. The second item is variance 2024-02. That's the one regarding the fence at the pool. Is there a motion to consider this?
I actually have some concerns with the way it's written.
Okay.
you don't mind.
Well, so let's start with the motion.
Mhm.
We'll get a second, and then in the discussion, you can suggest any changes that may be needed.
Can't approve it the way it is, though.
Well, we can't approve it, but
I
we,
would-
we have to have discussion, right, to either approve or deny.
Okay, I would do it the other way. I would discuss it first. But go ahead, whichever way you want to choose.
Once again, I think based on Roberts, I would say, do I have a motion to approve this as presented?
Okay. I don't make that motion.
Thank you. Is there a second?
Do not
No,
make
he
that motion.
didn't make a motion. We can make a motion, but then we can not approve, not approve.
I'll make a motion to deny this the way it's written.
Okay, that's fine. Is there a second to
Second.
Bill's motion?
Second.
Okay. Let's have some discussion about the information in here.
Okay. Can I go now?
Please.
As I recall, this was actually a variance for a 6-foot fence in an area where they're only allowed a 4-foot fence. And the way this is written, it's a little confusing on that point. I think in the top paragraph of the order granting a variance, it says it's a variance to allow an installation of a 4-foot fence measured from the top of a retaining wall. But actually, on the applicant's property, it's a 6-foot fence measured from natural grade ground level of the property. And I think that's the way that should read, rather than the other way around.
So, in,
So in other words, starting in the third line there where it says requesting a variance to allow, and I'll read it the way I would think it should be read, all right? A variance to allow the installation of a 6-foot tall solid vinyl fence measured from, and then cross out the balance of the retaining wall information and with the natural ground level of the property in the BR2 zone. Did that make sense to you?
Bill, that's an excellent point. I'm
Yeah.
sorry that I missed that, but that's the reason there's more than one person here.
so just make sure I understand what you're
Go ahead.
saying. That's okay. Requesting a variance to allow the installation of a 6-foot tall solid vinyl fence measured from the natural ground level of the property.
Correct.
Okay.
And carrying that same concept into the conclusions, I think the second page was fine. It is the third page where the conclusions come in. The first conclusion, about in the 6th line of that conclusion, it would meet the strict application of the UDO of a 4-foot fence facing away from the swimming pool on the adjacent property, but would not meet the strict application of the UDO on the applicant's property due to the rear due to the existing retaining wall.
Just switching it.
Yeah, it's so in other words, it's correct. It meets the 4-foot requirement for around a pool measured from the side of the fence facing away from the pool, which is what the ordinance, and I guess it's the state laws as well, require, state statute. And but it doesn't meet the strict application on the property of the applicant on the applicant's property because of the retaining wall.
So on
I
balance,
have that written here.
does anyone have any other comments?
I have another couple.
Okay, Bill, thank you.
Sorry. You okay with that, Ron?
Yes, I think I'm following,
He-
but
he-
you have it written.
He's
might
going
as
to
well
give you a
look
markup
Yeah, I can give it to
for
you.
us to get together.
Okay, on the second conclusion, third line, well, let's start in the second line. That sentence that starts, this conclusion is based on the fence complies with the 4-foot minimum height rather than maximum height, minimum height standard as measured from the side facing away from the swimming pool on the adjacent property.
Isn't it a maximum?
It's a max. The reason why maximum is there is
No. I'll get to that in a second. No, I was just saying that, see this, around a pool, you needed to have a 4-foot minimum height.
it's also the maximum in the district.
Okay, but it's a minimum facing away from the pool. And then so I was trying to say that it complies with the 4-foot minimum height as measured from the side facing away from the swimming pool on the adjacent property.
Bill, if I may interject, can
Go
we
ahead.
resolve this by saying the required height?
Sure. And then cross out the applicant's property and then say, and the applicant did not create the situation due to the existing retaining wall on a property to the rear of the subject site. He didn't build a retaining wall. You could do it that way, what you just said too, Larry, rather than all those words.
So
Go ahead. So
This-
say this conclusion is based on the fence complies with the 4-foot minimum height or
Required
required height as, I say as measured from facing away. This was what I took, those lines I took out of the state statute area that you had quoted, Ron. And it uses the term first facing away from the swimming pool. To me, that's on the adjacent property
but
in this case.
So just a question, I'm not challenging, just a question. So if the word required is inserted as the chair has suggested, is the sentence then, will it work as written?
Well, that would be this, I'm still stuck on that. It's, the conclusion is based on the fence complies with the 4-foot required height facing away from the swimming pool. The sticky point here was he was trying to meet that requirement and meet the 4-foot requirement on his own property, and you couldn't do both of them at the same time because of the retaining wall. You had to either meet the 4-foot with a 6-foot fence on his property, or meet the 4-foot on his property, and then it was too short on the adjacent property. Came out to be 2 feet.
Yeah, I get what you're saying. I'm just thinking the word required.
How to put it in
satisfies
here?
it. Well, that, but also I think the word required means it includes based on the fence complies with the required height standard as measured. I think the word required satisfies both ways.
Okay.
That's as I'm reading it, but I'm not sure how you guys have to vote on it. So, but whatever you vote on, we'll make sure we capture it correctly.
Okay.
Well, in fact, at this point, since this is not going to be an issue either way, we've indicated to the applicant that his application is approved. It sounds to me like there are enough changes here so that we could table the approval of this variance unless there is a statutory requirement that we approve it immediately. Since we're going to have another meeting in
Short order to
Pretty
improve the
soon.
minutes.
Yeah, I mean it's potentially would impact his ability to complete his project. And even though no one came to speak, the longer this takes to get fixed, then the appeal process starts once he receives this notice.
Okay,
So anyone who may be opposed, even though they may not have been here, they could still file an appeal within 30 days of once this from the date of receipt of this. So
as chair, may I suggest that we take a 5-minute recess for you and Bill to go work out the verbiage so that you can reprint this, we can get it into everybody's hands and approve it?
sure.
Let's do that.
Should I go talk to my third one, the last one?
Yes,
And,
please.
and before we go out, so down in the therefore category at the bottom, therefore it is ordered that variance to allow the construction of a 6-foot fence. It's
No,
a
you're correct.
6-foot height, the fence 6 foot in height. It's, sorry, because really the application was for a 6-foot fence, not a 4-foot fence.
But is it
And
from the
it's not
top of
that
the
it's off the
Measure-
retaining.
No, it would have to be measured from the grade
Right.
level.
Grade level.
Right, measured from grade.
Right.
And then you could also add, which I realize it's wordy, but working with some attorneys, they always told me that extra words don't hurt here. And 4 feet as measured from the existing retaining wall. So therefore it meets both conditions.
Yeah, and I understand the changes you're making. My mindset, the reason why I measured it from the top of the retaining wall or wrote it as from the top of this retaining wall, because it satisfied both from that perspective.
That's what I'm trying to.
And so that was the reason why when he even on the picture he was showing how it complied with that from the top of the retaining wall
Right.
as well. So that's why I focus on the retaining wall.
Yep.
You guys, you ultimately have to feel comfortable with the wording. So that was just not to defend what I did, but that was kind of my thought process.
Fine.
Right.
We're going to take that little break and do this now?
Yeah, I mean, Bill's correct that the fence is 6 feet. Right.
Yes,
From
Natural grade.
the natural grade, but it's 4 feet.
from the top of
And
the.
maybe if we put both of them in there, it can't be
Right.
misconstrued. So,
That's
Bill,
the point.
once again, I apologize for missing this. I'm glad that you caught it. And let's just take a 5-minute recess so you guys can work the language out.
Sure.
Get it printed up, and we'll be good to go. Is that all right? Thank you. All right. This meeting is in recess right now. to end the recess that we called and have a motion to reopen this meeting.
I'll move to reopen.
Thank you, Bill.
Second.
Okay, second from Jay. All those in favor?
Aye.
I don't believe any discussion is needed. So we're back in session here. We're reconsidering VAR 2024-02, which has been revised thanks to Bill for his various comments. I have read this. Has everybody else had adequate time to read it? Make
Yeah.
sure that's
Yeah.
accurate?
Yes.
Okay. If you are so inclined, would somebody please make a motion to approve this?
Make a motion to approve this as revised, Eric.
Bill, thank you. Is there a second?
Second.
Jay, thank you. So we have a motion to approve the order on VAR 2024-02. Is there any additional discussion regarding this? Hearing none, then let me call the question. All those in favor of approving this and having me execute it, please connote by saying aye.
Aye.
Okay, no one's opposed, no one's abstained, and the motion therefore carries. Thank you. And I will execute this once again as of the 9th day of October. And I'll deliver it to Ron.
Thank you.
Thank you all. Let's move on then to administrative items. Item 6 on your agenda. Ron has, or excuse me, misspoke. That doesn't need to go in the minutes, Robert. 5B is training. Ron's got some training. Can everybody see that TV screen there okay?
I can.
Yeah, I know there's one behind us as well.
There's also
Great.
one behind me.
Ron, all yours.
Okay. I can't see the screen too well, so I may have to look at that one behind you as well. So
Okay.
I'm going to stay here just in case I need to look up something on the computer. If you guys have a question specifically about the ordinance, there's not a lot of room right there.
Great.
Can we go out there?
Huh?
Can we go sit out there?
I'm fine with that if you want to.
Get a better angle on the TV.
Sure.
You okay with that? Yep. The only thing there is that if you had a question, you wouldn't have the mic. Well, because you do have your mic with you.
He's got his mic with him.
So, well, thank you for the opportunity to do some board training. I know we have at least one new member. Is that correct, Jay?
Mhm.
You're a new member. I'm not sure how long. Oh, so you're okay. So Bill as well. I'm not sure how long everyone's been on the board. So the chair had asked me to the COG could do some training for the board. I think periodically. I think the last one I saw was done in 2021. I
think that's right.
So I've got a series of about 30 slides or so. Try to go through these fairly quickly, but still, if you guys have questions or whatever, feel free to ask questions as we go through. All right, so legal context here. Local governments, like the town of Sunset Beach in Brunswick County, they are creatures of the state and really have no powers except the powers that the state gives them. There's two types of, and I'll throw in a little bit, but two types of, if you will, there's home rule and there's Dillon's rule. Home rule, local governments have broad authority. That basically you do what you do until the state says you can't. South Carolina is an example of a home rule state. You also have Dillon's rule, which local governments only have the powers that are expressly authorized in the general statutes for them to have. And North Carolina is somewhere between, but closer to a Dillon's rule state than they are a home rule state. Much closer to a Dillon's rule state than a home rule state. So there's only so much we only have the powers to regulate what basically the state says that we can regulate, what we can do. We can't. So if the planning board wanted to implement impact fees, we can't just implement impact fees. We have to go, there's a process, has to ultimately be approved by the legislature to allow impact fees. Just using that as an example. Let's see. Sorry, I can't see the slides that well. So I think I covered that.
Yes.
So there's 4 types of legislative decisions, land use decisions. The first one is legislative. They're policy decisions. There's the adoption of the Land Development Code or Unified Development Ordinance is a legislative decision. When council decides to rezone property or not rezone property, that's a legislative decision. There are also advisory decisions. They're not final decisions, they're less regulated. So an example of that would be someone's wants to try to rezone property, you have to go to the planning board. The planning board provides an advisory or recommendation to town council, but the planning board is not making that final decision. Same thing with the text amendment. Administrative decisions. These are routine activities that are handled by professional staff, but sometimes by a planning board or governing board. An example would be issuing a permit or not issuing a permit or approving a site plan or a subdivision plat. Those are examples. And then we have quasi-judicial decisions, and this is really where the Board of Adjustment kicks in. These are formal actions where in this case, the Board of Adjustment applied discretion in applying an existing policy to an individual or specific cases. You had 2 cases last month in which you had to provide discretion based on the evidence presented to you during your hearing, should those variances be issued or not. Yes, sir.
I have a question.
Sure.
I noticed in there you have special use permits.
Mm-hmm.
I could swear we had a bunch of special use permits that were in front of the planning board and the council and didn't come to the Board of Adjustment.
That I'm not sure about that. I don't know about the history, but I know your code requires
Well, at least they were.
special use permits to go to the Board of Adjustment. But some
apply.
jurisdictions, I mean, I'll use my former jurisdiction in Wilmington, North Carolina. Council was the approving authority for special use permits. They had to act in a quasi-judicial manner, just like you do. Sworn testimony, decision was supposed to be based on evidence presented then. Now, we'll go into the specifics of a special use permit in a few minutes. But the town gets to decide who is that delegated authority to make that decision.
Right.
Ron, if I may interject here, I think the issue is if the planning board doesn't issue a special use permit, I believe the Board of Adjustment is where you come to question that decision. And are you referring to the conditional zoning stuff that went on with?
Maybe it's conditional zoning. I was
Okay.
thinking of.
So had, for example, Riptide not gone to the town and got conditional zoning, which allowed a variation of uses that otherwise would have required them to come
To the Board of
with
Adjustment.
23 separate proposals to the Board of Adjustment. It was, within their bailiwick, they decided that the most efficient way to do it was to go to the town planning board and have the town planning board make a recommendation to the town council. But for example, if somebody came and wanted to take a piece of property that was zoned residential, not multifamily, and change it to multifamily, that would require a special use permit here. It'd probably be discussed at the planning board, but I think the ultimate approval would probably come here,
Right.
Unless they got.
Yeah, it was, you're right, it was the conditional use I was thinking of, not the special use.
Conditional zoning. Back in when 160D was implemented a few years ago, that was the new where they combined the city county planning regulations basically. They eliminated the term conditional use permit and made everything a special use permit. But there is, as you guys just talked about, a conditional zoning district, which is the most recent one was Angels Trace, went through the process. And in that, it's almost like its own zoning ordinance, different from a special use permit.
Yeah. Okay.
And we'll go into specifics in a few minutes about
Okay.
special use permits, and that's okay. Got too many things in my hands here. All right, so North Carolina General Statutes authorizes the establishment of a Board of Adjustment. It requires, stipulates 5 members appointed to 3-year terms, with alternates. The quasi-judicial procedures are required, and the statutes do allow for a planning board to function as the BOA, which is not applicable here in this town. The town has decided to have its own Board of Adjustment. The reason why 5 members minimum is established is, well, in a few minutes we'll talk about it, but a variance requires a 4/5 vote. You cannot have 80% or 4/5 vote if you only have 4 members. So if you have 6 members or 7 members, you still need to have 4/5 vote, which is still, and 6 members will be 5 of 6, 7 members will be 6 of 7, if my math is correct. So most communities establish that Board of Adjustment at the sitting board at 5 members, so it's easier math, if you will. So the Sunset Beach Board of Adjustment, your code says you will hear appeals of administrative decisions. You will hear requests for variances and special use permits. Typically, you have a chair, board members, staff, and attorneys at these meetings. The board chair is appointed by the board members, as well as the vice chair. The board's chair's role is to call the witnesses in the order set by the board's rules of procedures. They make sure the witnesses stick to presenting only relevant evidence. They make any rules on any legal objections that are made unless the attorney is present and can provide some guidance. Chair usually votes, and in this case, the chair does vote. And the chair will act like a judge in a civil or a criminal case, maintaining focus and making sure the proper procedures are being observed at all times during the hearing. Again, at the last meeting, we had Mr. Richardson here who provided that guidance and assistance. And when the attorney is here, they will provide that guidance and assistance. So we also have individual board members. The expectation and role is to be familiar with the ordinance and the standards, be knowledgeable about the process and the rules they must follow, which is why we're here today, is having a training session so everyone can understand what those processes and rules may be. Be attentive listeners, and you are. And that was obvious to me last month. I saw that each one of you listened to the cases and the evidence presented, and the deliberations were based on the fact that you were able to intently listen to what was being presented. So then staff here, a lot of times the staff is the initial witness at an evidentiary hearing. And what does that mean? You saw that I was sworn in last month, and I provided the information based on what I knew and what I had. And we enter the case summary as a exhibit. We usually staff is testifying as what the ordinance requires, summarizing applications received and recounting any staff analysis or review of the application. And then we also have attorneys present. We had our board attorney. You also had an attorney. No, you didn't. I'm getting confused. But sometimes you'll have an attorney from the applicant who may help present information or guide the information, call witnesses. So I was getting confused. Planning board last meeting, we had an attorney present, so that was where my mind was. Sorry about that. So first item we had was an appeal, and a case must be the appeal of an actual staff determination or an action. Appeals of an advisory opinion are not allowed. And what does that mean? It has to be a written record. So someone would ask, how are you interpreting this ordinance? We would then provide an official determination. It's not just, well, we think that the code is, or we're going to advise or recommend. It has to be an official determination before an appeal can be filed. An appeal is to be brought by a person by a party with standing. That means they hold property interest that is specifically affected by that decision. And that appeal has to be made within 30 days of a notice of a decision. Who has standing? Sometimes this board makes that call.
I was just going to ask, yeah, we get
Yeah,
to make
it's-
the choice on that. Okay.
It's sometimes you would think it's obvious, sometimes it's not as obvious. And it may also include a neighbor appealing the issuance of another neighbor's permit. And I underline the word may there is because I don't think that's always the case. There was a case in Raleigh, Cherry versus the City of Raleigh Board of Adjustment, I believe was the name of it, in which an applicant, Historic Preservation Commission, approved certificate of appropriateness for that particular, whatever the property owner wanted to do. A neighbor then appealed. And at some point, the city and the applicant appealed the neighbor decision. And the Supreme Court, or the Court of Appeals, I believe it was, in North Carolina, ruled that that neighbor did not have standing, ultimately. So it's not, that's what I'm saying, it's not always as cut and dry as you think. You would think maybe if you're to live across the street or next door, that you would have standing. But based on the information for that particular case, Court of Appeals ruled that the neighbor did not have standing. So it's not cut and dry, but typically the board gets to make that decision if the standing is there or not. Okay. Appeals must be heard in a reasonable time and notice is required. Official who made the decision, whose decision appealed, must provide relevant documents. Sorry, I need to advance that. An appeal of a violation stays enforcement of the action and any assessed fines. And on that appeal, once all the evidence and you've gone through the hearing, the board can reverse or affirm in whole or part the appeal decision. Parties may agree to mediation or any alternate resolution. And then sometimes the person with standing can bring it straight to court. Appeals typically come to the Board of Adjustment, though. These are appeals of the land of the Unified Development Ordinance. It's an interpretation that staff would make, whether a use is allowed or how the particular regulation applies to a situation, and the applicant or neighbor didn't like that, they could appeal to the board. Any questions so far? A little bit of standing here. All right. Apologize if you can't read that too well. So any person who has standing or the town may appeal a decision to a Board of Adjustment. And the statutes in 160D, 402C stipulate people with standing would be the owners of the property or someone with an option to purchase or lease the property and an applicant for a development approval. I mean, they have some teeth in that. Any person who will suffer special damages. I think this is where the gray area gets. What are special damages? May include parking, stormwater runoff, and crime problems or property value impacts. Proximity alone is not enough to prove such, going back to that Cherry case that I was just mentioning. An association of neighborhood property owners that will be affected, provided that at least one member of that association has standing as an individual, and that the association was not formed in response to the particular application being appealed. So let's real quickly pull together an association, say, to give us more. And then the unit of government that has made a decision being appealed obviously has standing. And standing is important too for participation of third parties in any quasi-judicial proceeding. So I'm going to jump real quickly. That's specifically for the appeals. I'm going to go ahead and move forward to variances unless you guys have any questions so far.
Good.
And I'll touch on standing a little bit later too. All right, so variances, General Statute 160D 705 gives the board permission to modify provisions of the ordinance to prevent unnecessary hardships where, and from your last two cases, you're somewhat familiar with those hardships. Hardship results from the strict application of the regulation. And I thought this board did a good job last month with the first case when you threw out, well, is it really a hardship because there's some other options? And that was reflected in we tried to make sure that was reflected in the order as well. You may have picked up on that.
It isn't, hardships are related to the land as opposed to individuals' desires and
Correct.
money and cost and
Correct.
those kinds of things.
Correct.
They're factors, but they're not associated with a hardship.
Right. Health hardships or financial hardships.
They're
While
not.
you may be empathetic or sympathetic to some of them sometimes, it really is, your decision shouldn't be based on those. It really has to be the lay of the land.
Could be somebody else owning that property,
Right.
not them.
And evidence presented during the hearing, and that's key in
Yeah.
each one of these.
Mhm.
Has to be evidence presented to you during the hearing. So the other hardship, and this is kind of where you're talking about, Bill, is the hardship results from the conditions peculiar to the property. Hardships resulting from personal circumstances, as well as hardships from resulting from conditions that are common to the neighborhood of the general public, may not be the basis for granting a variance. So again, it's what is about that property that's unique to everyone else, or that situation? What is unique about that situation? Third one is the hardship did not result from the actions taken by the applicant or the property owner. And then the fourth is the requested variance is consistent with the spirit, purpose, and intent of the regulation, such that public safety is secured, substantial justice is achieved. And public safety, you use that as part of your rationale. I believe the second case that you granted last month, the variance fence height, that was part of the deliberation and information and evidence you received, and ultimately your decision was use that as part of your decision on that. So a couple things for variances: you cannot vary a use. So if the code says that retail use is not permitted in this zoning district, the applicant cannot cannot submit a variance to the Board of Adjustment and say, hey, we want you to vary your code and allow this retail use in this particular situation. Use variances are not allowed per the state. Yes, sir.
Ron, if I may, though, it is possible that somebody that has a residential property could go to the planning board and ask for a rezoning, couldn't they?
Sure. There's a couple options. There's a couple options. They could ask for rezoning. They could ask for a text amendment to allow that use with standards. Maybe the text amendment to allow it as a special use permit that has to come back forward. So there are options: amend the code or amend the map.
Okay. But in the event that somebody had a residential property that they wanted to change the zoning to retail, and the planning board rejected that request, wouldn't, based on the action of the planning board, wouldn't that potentially be appealed to the BOA, or once it hits the planning board, is it a dead item?
Well, first of all, the planning board doesn't make the ultimate decision. They're advisory. So it would go to decision, then would go to council. Recommendation would go to council. Council would decide. If council denied it, that then goes to the Superior Court. It does not come to here.
Okay, so we're out of it.
Correct.
Okay, thank you for that clarification.
Yes, sir. I thought that was what you were hoping to get.
Yeah, yeah.
And the recommendation here is also that the board vote on each of the four provisions. So those provisions, the four hardships, or the four provisions on the two previous slides, it's recommended that you go through 1, 2, 3, and 4 and provide the evidence on why. What are you using to make the decision or base that decision on?
But do you have to meet all four?
To get a variance, you have to meet all four.
Correct.
You could
But if a denial doesn't require you could meet 3 of the 4
Correct.
in a denial.
Correct.
But you don't meet one of them. So.
Correct.
Okay.
And for a variance, and I should have clarified this too, the first item we talked about was an appeal. It's a simple majority approval. So 3 of the 5 members could say, we agree that the appeal should be approved,
Right.
and it's approved. Variances require that 4/5 vote. So that's where I would recommend, if we only had 4 members at a meeting, for whatever reason, we let the applicant be aware of that and the applicant decide whether they should move forward or not, because with only 4 members,
Gotta
they
get
have
all
to have
four.
unanimous approval.
They have to get all 4 of them.
It can happen. So moving to special use permits. Special use permits are special use permit allows a certain activity or use to be established in a particular zoning district or location within, if the applicant can demonstrate that certain ordinance requirements are met. And majority of your special use permits, there's going to say you can have this cell tower provided there are, here's 10 criteria that you have to comply with. So specific ordinance standards associated with
Those
that.
sound like conditions. Makes it sound like a conditional use to me.
Well, they're not conditions. They're other parts of the code that apply in that situation. And I say the difference because conditions would be, like in a conditional zoning district, that are potentially above and beyond the standards of the code, or even in the conditional zoning district situation, maybe something is relaxed. Because again, it's its own little zoning district. So these are stipulations that are already listed, and the applicant has to show how they will comply with those criteria.
Okay.
The use is not permitted by right. So it's more than just them coming down and trying to get a permit to move forward. They have to go through, it requires an evidentiary hearing. Notices to neighbors provided for the hearing. Went through your code and just listed what I could see real quickly, what uses require a special use permit. And certainly I won't list them all here, but multifamily and townhome developments in several of your districts are allowed with a special use permit. Commercial outdoor recreation in the MB2 and the MUD districts are allowed with a special use permit.
Did you explain that last bullet? Yeah. It's not a
Not a public hearing.
Not a public
Yes.
hearing here. Public opinions from the public at large, but
Right.
it's still a public hearing.
It's an evidentiary hearing, which is it's hard to differentiate. And
So you don't have evidence presented by the public that might be impacted by this, is what you're suggesting. It's only evidence associated with the applicant and other witnesses that are special witnesses, ones that are qualified for it, like engineers or.
I mean,
approach with standing. And it's a hard.
That's why I'm getting a little.
It's hard sometimes to differentiate. Sometimes you don't know what their application is or applicability, until they start speaking.
let me try and deal with this. If you were going to do something to your property and it was going to create a runoff issue, your next door neighbor could show up with an engineering, a qualified engineer's report showing that what you were proposing was going to damage their property. And that would be evidence that we could accept. But if they just want to show up and say, Bill's going to do this thing and I think there's going to be runoff on my property, they would not have the standing to actually be recognized and make that comment. Am I right on that?
Yes, sir. And sometimes you don't know that until they actually speak. And so then once it's out there, you as the board has to decide, was that evidence or hearsay?
Gotcha.
And I'll get in a minute here about maybe even be the next slide. Let's see. It's a couple slides later, but it's about sometimes you'll have a traffic expert who's providing you an opinion instead of what the traffic impact is going to be, or an engineer. Chair just mentioned stormwater. Well, it's an expert opinion based on
you get wait a second here. You get it's traffic engineers and their reports. I mean, it's an expert witness, but it's still their opinion. I'm sure you could find another traffic engineer.
But
who
the
would say
courts have
something different.
upheld. The courts have upheld as that being different from someone just living in a neighborhood and saying, "Hey, I know there's going to be a whole bunch of traffic on the road as a result of this."
Well, if they do a study and they present a report that shows, levels of service at traffic signals, et cetera, and Okay.
Yes, sir.
So standing can be other than people who were just notified in writing of the variance request, or the,
It's if they can show to prove to the board how they are being directly impacted by the decision, the board can make that decision
okay.
on the standing.
For instance, we had a case where they had the cell tower over by Regency.
Mhm.
The people behind it, I think on
Oyster
Oyster
Point.
Bay.
Oyster Point, they were claiming diminished value and radiation, I think, were two arguments. Those would qualify as,
They'd have to. I don't know the specifics of that case and how they felt like
it's a
they
cell,
had
it's a
standing
cell
for it.
tower, and they were complaining about the cell tower.
But I believe the statutes have been changed to just impacts of the radiation or whatever folks would say is not something that could be used now, I believe, is what I've heard on that.
In that instance, while we did allow broadly people to comment, the folks who were seeking approval actually had information from a qualified engineer that showed that the whatever it is, rads or whatever of
Radio
radiation
frequency engineer.
that came out would be less than what you get when you hold a cell phone to your ear, and pretty much shut those folks down right quick.
Right. And that's I've got it on a slide, probably about 8 or so slides now, but
Okay.
it's what the presentation, I should have mentioned this earlier, is talk about specific things that you hear as a board. And then I was going to go into a little bit more about what is deliberations and competent evidence and those kind of things that you need to consider. So later, about 8 or 10 slides, I'll have competent evidence as one, where the witness must present facts, not opinions, but an expert witness, such as an engineer or someone, how they factor into that, where they are providing opinions, but the courts have outlined. So hope that's okay. Maybe we can talk about that in a few minutes. I got too many things in my hands here, pushing the wrong buttons. All right, so special use permit, the decision is to be based on the standards in the ordinance. The burden of proof is on the applicant to show how they have satisfied those standards. And then if sufficient evidence is presented to show how the standards have been met, the board must approve the permit. If you find that the evidence has not been met, then it has to be denied. And that's important to hear, because I'm sure with a cell tower, you may have had a room full here of folks.
Oh, we did.
So they're not always a popular opinion, where a legislative item that goes in front of council can hear that, okay, well, there's 50 people here against this. Maybe it's not the best thing for us to approve, a rezoning or a text amendment. But with these quasi-judicial cases, even though there may be 50 people here, if the evidence says it needs to be approved, you need to approve it. Flip side of that, no one can be here, but if the evidence says don't approve it, then you shouldn't approve it. So it's not always going to be easy sitting in this seat to hear these cases, but I think you made a great statement in conversation earlier, Mr. Chair, talking about how the board, the last meeting, how the deliberation and everything that you guys use to make the decisions on those cases. It was based on the information evidence presented to you during the meeting.
It's not a gut decision. I made the statement in the cell phone case. I said, I understand your concern. I wouldn't want one of these in my backyard, but they have met the burden of proof regarding why they qualified for the approval. And we approved it. This may be instructive for you. We approved it, but we had a number of preconditions to that approval. One of which was that they comply in all respects with the state's requirements regarding stormwater management on that parcel, and that they provide written evidence of the state's approval thereof. And as it turned out, they were unable to do that. Then proper period of time, and they abandoned that project.
Okay, that's good to know. And I'll talk about conditions here with special use permits in just a second.
Yeah, thank you.
All right, so the next slide here is your standards for review. Those of you who have sat through a special use permit or should be familiar with these. These are found in the Unified Development Ordinance. So the use will not materially endanger the public health, safety, and general welfare if located where proposed and developed. That it meets all required conditions and specifications. The use will not adversely affect the use or any physical attribute adjoining or abutting the property. And I have and capitalized there because again, all of these have to be met, not one, two, or three of the four. And the location, character, use will be in harmony with the area and in general conformity with the town's comprehensive plan. And that's information as a special use permit is coming through you. Town staff should provide. Here's what the comprehensive plan shows about this. Here's what the code. The number 2 that meets required conditions and specifications. Here's what the code, here are the required conditions and specifications that apply to this. Here's how we feel like it should, they're missing here or they have addressed them all. And in special use permits and variants, I should have said this earlier. I did mention this during the hearings last month. We're not making a recommendation on them because your decision has to be based on the information and evidence presented to you during your meeting. We're only exposed to the information on the application and any evidence that we can gather as we're preparing the case summary. And so we're not going to make a recommendation to you because we don't have the full picture until the hearing's finished, just like you. Does that make sense?
Yeah.
All right, so there are conditions that can be placed. But there's also some these, and this slide are actually things that you shouldn't and cannot regulate, and these are straight out. These are in the ordinance, but it's also in the general statutes. The ordinance almost quotes the general statute specifically here. So you cannot impose a condition regulating taxes or impact fees, building design elements for 1 or 2 family homes, or any driveway related improvements in excess of what's allowed by the general statutes or anything other unauthorized limitations. So sometimes, that may be, you want to put some additional standards. So you want to increase the buffer from 30 feet to 40 feet. That's probably appropriate in a case. But if you say, okay, we're really, I'm not saying a subdivision would have to have a special use permit, but just using this as an example. Well, excuse me, we want all your homes to be brick, and we want, to do your certain door color, and those are things you could. Or we want you to pay an impact fee of, $5,000 per sewer tap to help offset such. Those are things you cannot put in a special use permit as a condition.
Would you be able to advise us on, I think it was driveway-related improvements in excess of those allowed? The in excess of those allowed is so. But I mean, during a hearing.
Sorry, Alan. Thank you. No, mine.
You're up. Okay.
I've got this in my hand and I have this in my hand. I keep hitting the wrong button.
Turn it on.
So yeah, we would be able to pull those statutes up during the hearing and say, well, or we would even have information prior to.
Yeah.
DOT says really this, and those are Department of Transportation standards.
Mm-hmm.
Those statute references, and this is what
So
they're.
that's like, road entry, the curb cuts and stuff like that you're talking about there.
Correct,
As
and
opposed to driveways within the facility. In other words,
it's outside. It'd be the exterior driveways, as an example.
as opposed to the size of the aisleway between parking spaces.
Correct. If I follow your question correctly.
Yeah, you
Yes.
could.
But what you couldn't do is, here's maybe a bad example, but neighbors are here and they're talking about the traffic, and you believe you want to put a condition that the signal timing quarter mile away on the such and such needs to be looked into, and that's a condition that would be outside of the realms of what those statutes would say.
Okay.
That's one I definitely know is in there. So, but there are all the specifics in there. I don't know them all. So some reasonable and appropriate conditions may be imposed. I believe you'll just use an example of one for the cell tower. Well,
Right.
show us how you comply with the state stormwater. You said they couldn't do that. Conditions that run with the land must be consented to and in writing. Time limitations are permitted. And
We gave them 6 months and then they asked for an extension.
right.
We gave them another 3 months and they still couldn't comply.
Conditions which require one or more things be done before the use requesting can be initiated. Again, that the stormwater is an example, and this actually is in your code. For example, that a solid broad fence be erected around the site to a height of 6 feet before the use requested is initiated. That's an example that's provided in your code. Conditions of a continuing nature may be imposed. For example, exterior loudspeakers shall not be used between the hours of 10 p.m. and 9 a.m. That's a condition that's an example that's already listed in your code. So you can list conditions as well, and on top of the other criteria that you're considering. And staff will be here, and if the attorney's here to help guide those that may be appropriate versus those that aren't. All right, a little bit about procedures, and I've hit on this a little bit. Quorums depend on local ordinance, simple majority or 4/5. I believe your ordinance is 4/5. For voting requires 4/5 to grant a variance. I've touched on this already. Simple majority for a special use permit or to affirm or deny an appeal. And there's some stipulations that are in the code and the statutes about vacant seats, how we count that. And then hearing is an evidentiary hearing to gather facts. It's not a public opinion. The statutes require a detailed record of the hearing, including detailed minutes, and then hearing for each case must be opened and closed. Witnesses, evidence must be presented under oath, and cross-examination is allowed and must be allowed. The oaths can be done by the chair of the clerk, and then even the chair or the board can subpoena witnesses if necessary. Doesn't happen often. I think of maybe one time in my career where that's happened, but it's not typical. It doesn't happen often. Written findings of fact are required. Where there is a conflicting evidence, the boards must specify what it determines to be the facts that are based on the decision. I think we went through that a little bit today with the orders. Case summaries, we're going to provide application, any materials that are submitted along with the application. You saw in the last month, any written correspondence that staff had that were relevant to the case we provided. And then we even listed that in the bulleted list in the case summary. So you're going to get information up front. That doesn't mean there won't be other information introduced during the hearings. But that's, we're going to do our best based on what we have. We're going to do our best to get you the information that we have. So you walk in at least with a little bit of knowledge and know what you have before you. Yes, sir.
So there was a comment made at the last meeting. I think Grady made it, that we should not go to the actual site. And that was at odds with my understanding, was that we were entitled and encouraged to go visit the site so that we wouldn't be misled by site plans or pictures that were done at specific angles. What is the actual rule when we know that we have a variance hearing coming up, a special use permit coming up? Can we or can we not, or is the law silent as to our ability to physically inspect the premises ourselves?
Well, first of all, I think you should do what your attorney advises.
Okay.
and he's advised that his preference is you not visit sites. And I'm going to actually have a slide. I'm going to talk a little bit about site visits. But when I get to it, we'll just brush over it because I think we'll have a bigger conversation now. Well, sure.
I think it depends on the case. In the case of the cell tower, you were talking about a vacant piece of property. In the case of the swimming pool, you were talking about a private property that you would not be able to enter upon unless the applicant was there, which would cause communication, and you could not have that communication. Does that help?
That's my understanding of it as well. Driving by a site should not be disqualifying. It should not be. There's what could be wrong with driving by and looking at what's going on. But entering a site is a different story.
And I did some reading yesterday just to brush up on what does the School of Government advise and those kind of things. Again, follow what your attorney advises.
Yeah.
But same thing with site visits. Why the attorney may be advising avoid it if you can. Lisa was spot on.
Particularly for the communication aspect of it.
So you may walk out there, but regardless, if you drive by and let's just say it's and you see something about that site, that is getting evidence that is outside the confines of the hearing. So if you do visit a site while your attorney's advising not to go, you need to disclose that. Hey, I drove by that site. I saw XYZ going on. That way, then it's part of the record and is disclosed, and every member of the board who's there to make the decision hears and has that information available. That would be the advisable thing. If you happen to drive by, definitely don't get out and walk around. Meet with the applicant, meet with the neighbors, because they will share their opinions. And we'll talk about ex parte contact in a second. Just disclose that during the hearing. And I believe someone did say, hey, I drove by and I saw. So just.
If I had driven by, I don't know if I could have got a really good picture from the evidence that they were giving us. But once you saw what was there, and you could just see it from the street.
Right.
It was very evident what they were trying to do.
I think the attorney's concern is that you're getting that evidence outside the record, outside the evidence, and that's where I can't speak for Grady on his position on that, but I think that's what his concern is. So the School of Government says if it's not advisable, but if you do it, make sure you're disclosing that information to the board. While I was out there, I saw XYZ. Does that help answer the question?
Thank you.
Let's see, did I actually talk about these? All right, conflicts of interest. Constitution and the statutes give parties to quasi-judicial decisions the right to an impartial decision maker. So conflicts of interest must be avoided. And conflict of interest in this case certainly would cover, okay, I have a financial interest, or they're my next door neighbor or whatever. But also I think it would cover, particularly for these quasi-judicial cases, I've looked at this evidence and there's no way that I can approve this, or there's no way I can deny this. If you come in with a biased mind, that's a conflict for either the applicant or anyone who may be opposed to that situation. So that's why the key there is the impartial decision maker. Walk in here with an open mind. I'm here to hear the evidence. I don't have any predetermined conclusions in my mind how I want to vote. I'm going to hear the evidence, and it's different from a legislative hearing. Planning board coming, with there's no way I'm going to recommend approval of this rezoning. You have a different role, and just understand that you need to have an impartial decision. Yes, sir. And open meetings. All meetings and all deliberations must be open and to the public. I can't think of a time where the Board of Adjustment needs to go into a closed session for anything. Maybe I'm wrong, but I can't think of a time where the Board of Adjustment is, hey, look, let's go to closed session and talk about X before then we'll come out there and make a vote. That's something we can do, and I'm not seeing you guys request that. I'm not saying, and I'm not even actually seeing other boards do it, but in any deliberation, decision must be separate from the hearing. So any time a majority of the board members gathers in person or electronically, you're in a meeting. So an email goes out, and I know we send an email and say, hey, here's the board agenda. And you guys start responding and having a conversation that's going on and saying, hey, well, did you see such and such? Or if a neighbor or someone emails the Board of Adjustment and starts having, that's an open meeting in violation of open meeting laws. So we've got to be very careful with that. We do full and accurate minutes, and then avoid discussing public business at social gatherings. So I know the town of Sunset Beach is a small community. You guys probably run into each other, potentially run each other in social gatherings or wherever the case may be. And you start talking, don't talk about business. Don't talk about the upcoming case or anything that may be coming to the board that you're aware of. That is in violation of those open meeting laws. Just be very, very careful on that. And it's hard. And sometimes you don't know going into it that, oh, that's what the neighbor's talking about.
Right, but so and this is a big issue because Kimberly is very good at sending the information out to everybody. But for example, Bill and I play at the same golf club. We have to avoid any discussion of an upcoming case. We can't exchange emails. We can't talk about it or whatever.
Correct.
As much as I'd let you know, if Boomer sees something that he thinks affects the case, he has to keep that to himself and not contact me or contact Jay or whatever until we get to the hearing, at which point he can disclose what he knows or what he's seen, but it's totally transparent. Is that
Correct.
a fair statement?
That's fair.
Okay.
It's hard. I mean, you guys are friends. You know each other. Town's a small town. You're going to interact. Okay. It's not saying you can't hang out. It's just saying don't talk about business while you do hang out.
Yeah, just say, sorry, can't talk about that.
And that will go with neighbors and stuff, and we'll touch a little bit on ex parte contact here in a minute.
So no reply all. When you
Correct.
get something from Kim, you just can't use reply all. Just reply to her, please.
And also, at least in the jurisdictions I've worked in previously, and I think the town would have the same rule, but every email you get with a public email, so we send you that agenda, you're a representative of the town, and your email is subject to public records laws. Text that you may get or doing amongst each other. If someone says, hey, I want all records that the Board of Adjustment has on that cell tower case, and you guys have been sending text or receiving text from neighbors, that's potential public record, and part of the discovery would have to be turned over should that be requested. So just be careful. And as technology advances, that's something we really need to make sure all of our board members know, not just planning board, but not just board, but planning board and council members and others. I've had my own text as part of a discovery when I was in Wilmington for a controversial case up there.
Yeah, you're making me think we should use separate emails for this.
Regardless, if it's public record, if it's public business, and you're exchanging information, even over the private email.
No, but I mean, I understand that, but I'm thinking, I guess, should have Kimberly send me, if she's going to send me information, she should send it to an email that I don't normally use. Separate.
That's up to you. I mean, it's the only thing we're going to be sending you will be the agenda
One that I
of the
only use
cases.
for this activity. So if it's subpoenaed, they get this activity.
I mean, that would be a decision up to you on that. And I don't mean to say that to scare you. It's just more just be aware. So I don't think board members understand that.
Most of the ERC members do have a Gmail account that is specific for ERC business. That is separate from their own.
Not sure I'm remembering what ERC is.
It's the Environmental Resources Committee.
Okay, got it. I'm going to change my email, Kimberly.
All right. Moving on to evidence. When you're hearing evidence, that evidence must be substantial, competent, and material. Competent evidence is trustworthy, it's reliable evidence. Material evidence is related to the standards of the code. And this evidence must be entered into the record and kept on file. Hearsay and non-expert testimony cannot be the basis for a decision or for establishment of a fact. And board members, this is we're going to the site, by the way, board members shouldn't be gathering evidence outside of the hearing, and ex parte contact is not allowed. Does everyone understand what ex parte contact is?
Yes.
That's
And just for your knowledge, this is a mistake that I made when I was early on in this committee. I actually went to the public records and brought up the site plan of the property that we were hearing a variance on. And having done that, it allowed me to catch the applicant in a lie, where he basically said that his 12 by 20 deck was substantially what he had had before, which was 5 by 8. And although it didn't affect the overall decision, Grady counseled me and said, you can't go out and try and generate your own evidence. And so I was guilty as charged. But I didn't know that I wasn't permitted to go out and do that.
And it's hard, I mean, because your decision is supposed to be based on evidence, right? But your decision is supposed to be based on evidence presented during the meeting. And that's where, you know, if you think of yourself, I don't want to say exactly like a judge and jury, but you don't typically have the judge and the jury going out and finding evidence outside of the court case. I mean, not that I'm familiar with anyway. So if you kind of think of in that realm, even though you're not the process isn't strictly like a case, but just kind of keep that in mind. If I was the judge or the jury for this, can I go out there and discover evidence? And your role is not to discover evidence. Your role is to make a decision based on the evidence presented. Now, you can do that by asking questions of the applicant. Can you clarify what size of deck was there already?
Thing was, he said it was substantially
Right.
similar, which I knew to be an outright lie.
And I wasn't here for that case, so I don't know exactly the specifics, but so it's a fine line sometimes there. So I talked about site, and then ex parte contact communication should be avoided and disclosed when it is not avoided. Doesn't necessarily mean that I inadvertently talked to the neighbor because I didn't realize it was a case until they said what was going on until they actually. That doesn't mean, okay, well, now I just can't sit for this case, but you should disclose it. But avoid it if at all possible, avoid it. And you do that by somebody calls, somebody emails, sorry, I can't answer that question. You can do that by not visiting the site and walking around and hoping and encountering the neighbor or the applicant. One of the cases last month, when I was communicating with them, they said, well, certainly they're going to come out and look at the site. And I can ask a question. No, absolutely, they shouldn't be stopping by and talking to you. So I would hope they're not. And that's before I even knew you guys, you know. So he just assumed that it was going to be a conversation that he could have with any member that may have just walked out there and knocked on his door and wanted to communicate and go to the backyard and see what was going on. And so I had to use that as a teaching moment or advising for the applicant as well. So again, underline there, only the evidence presented during the hearing and is what you need to consider your decision on. I know I've said that about 10 times, but that's important. Which is also, again, and the reason why when I prepared the order following the hearing, I went and listened back to the meeting and tried to introduce testimony that was done on both cases. Try to build the record to help substantiate the decision that the board made. Just the bulleted points I put in the case summary wasn't enough to ultimately on the decision you landed on. So we need to go build that case and that record for that. So competent evidence shall not include the opinion testimony of lay witnesses as to any of the following: the use of the property in a particular way affects the value of other property. What does that mean? Well, they put this here, and I think this is going to my property tax is going my property values will be decreased by 10%. Well, what do they have? What's the basis of that? Are they an appraiser? Are they qualified to make that decision? Maybe there's an appraiser that lives there. Maybe they aren't qualified to do that. Or another one be, well, they're going to put this here, and then traffic's going to be increased tenfold, and I already have problems getting out of my driveway now. I will never be able to get in my driveway with this use here. Well, you've all heard it, right? That's not competent evidence. Matters with only expert testimony would generally be admissible under the rules of evidence. And this goes what I was talking about earlier about the the one exception to the rule that witnesses must present facts, not their opinions. An expert witness is allowed to present their professional opinion about two issues that often arise in land use disputes: the impact of proposal on property values and impact of traffic expected to be generated on public safety. So that's where an applicant or opposition could have an appraiser to come in and testify and provide their opinion, but expert opinion on something, just as an example. And you also saw, you'll see sometimes where the engineer for the applicant, the pool guy spoke the other day, but the engineer for an applicant may provide information.
Right. Do you typically find that expert witnesses have to be determined to be an expert? They have to
Qualified.
show their qualifications, discuss them, and then we have to agree that we accept them as an expert?
What I've seen typically is you would have, when I've seen it done, typically let's say an applicant has brought in their traffic engineer.
Correct.
And usually there's an attorney that's helping them with their kind of, calling the witnesses, if you will. And you'll start out and say, okay, what is your name? What is your profession? What are your titles?
Run through their qualifications.
Right, and they'll run through their qualifications. I'm not sure how you would challenge their qualifications unless you had done some inspection and tried to, well, are they really certified by the State Board of Engineers? And so then your evidence finding.
Okay, but does the board have to accept them as an expert as opposed to could they reject them as an expert? If, in fact, the engineer that comes before the board no longer has a license because of whatever reason.
Ron, I'm a registered engineer.
Okay. Thank you.
If they tell you they're an engineer in a public hearing and they're not registered, they got a problem.
Yeah, I was gonna say,
That's a problem in itself.
Yeah.
Yes. And there's some times where we have to rely on, even like on a site plan review. Okay, well, the engineer says that this is going to work. I'm not an engineer.
Based on their calculations and such, yes. Right.
Also, engineers have an obligation not to testify or not to work outside of their areas of competence. So it is appropriate, in my opinion, to query, even if the guy is registered. I'm a registered electrical engineer, but I'm not going to give you an opinion on civil stuff. I don't know much about dirt. So, it's appropriate that you can query, just because a guy calls himself an engineer and is registered,
Right.
You can query his expertise in that particular field.
Yeah, and I think that's where the minutes and then the order could reflect that so-and-so is a certified electrical engineer, and we're talking about a civil matter, a
Right.
civil engineering issue or
Which
stormwater.
would
or traffic.
challenge his expertise.
Correct. And then, but your decision then could be based on.
Now, interestingly enough, my registration is general, so if I acquire civil expertise, I could then represent myself as a civil engineer.
Okay.
But that's where we hope Grady or someone is here going to help advise on some of that as well.
So Ron, based on your professional experience, would a misrepresentation or non-factual statement that was relied upon by the board to approve a variance foul the punch bowl to the point where that approval could be overturned? In other words, Bruce said he was a mechanical engineer and that the structure would be perfectly fine. We say, okay, we agree. And then it turns out that he is not in any way certified. And somebody says, well, you know what, this thing's going to fall down. Would they have a basis to challenge the approval that this board had issued?
Sorry. Thought I had already had it on. To me, first of all, I think that's for the courts to determine. And
Okay.
the person, if let's say, and somebody appealed the decision of the Board of Adjustment, or the town, or let's say a person appealed the Board of Adjustment, the courts would have to determine if that person has standing first.
Okay.
And if that person was found to have standing, then they could use that information as the basis of maybe why the decision should be overturned. But the court has to make that call. It's not, or the town could, if the town council got wind that something was approved and they wanted to appeal it based on potential misinformation, the town would, just we've already went through, has standing.
Once
the
it's
town.
through us, it goes to the court.
Correct. So, so it's. I would think they would have some basis, but that would be ultimately for the court to determine, and the applicant and their attorney or staff, whoever they were using to make that case, and why they felt like that person was misrepresenting themselves or unqualified or whatever the case may be. I can't challenge an engineer. As a non-engineer,
I could ask them, what is your experience in this particular field?
Yes.
Just because they say they're an engineer doesn't mean they're qualified in that particular field.
Exactly.
So it's, they have to have relevant experience. And if you catch them in a lie like that, you can turn them into the Board of Registration, and they will, they'll have to go through a legal process there.
And their swearing in statement says that they are here to tell the truth, the whole truth, and nothing but the truth.
Mhm.
So if they take that oath and then stand up and tell you a lie, I would think that evidence could be disqualified if you could prove it during your hearing.
You can also make them an ex-engineer too.
Mhm.
We talked a little bit about conflict of interest already. We'll go a little bit more specifics. Members are disqualified from participating in the following situation. We talked about that fixed opinion already. If there's any undisclosed ex parte communication discussion regarding the case, or a close family business or other relationship with an affected person, and then that's defined as a spouse, parent, child, brother, sister, grandparent, or grandchild, includes step, half, and in-law relationships, or any financial outcome. Bruce, you're an engineer, and I don't know if I don't think you're employed now, but let's say the firm that you were employed with was the applicant or representing the applicant, you probably would need to disclose that and potentially recuse yourself because of potential financial impact. So then if any objection is raised and a member refuses to recuse, and the rest of the board takes action on that. And I've seen that happen before. Parties and witnesses. Parties with standing have rights to present evidence, cross-examine and inspect documents, object to testimony and evidence, and offer explanations or rebuttal. So those parties with standing. A lot of times you may have to decide standing, and I've seen it where an applicant, their attorney questioned whether or not an opponent had standing, and then the board had to go through the process for that person to outline why they felt like they had standing. The board had to make a decision on whether that person had standing or not before they allowed the proceedings to move forward in cross-examination or whatever. So an attorney can represent a party and act on the party's behalf based on ethics opinions from North Carolina State Bar. Non-lawyers may not provide legal advocacy on behalf of a party. And I believe that's where, if Mr. Richardson's here, he'll jump in a little bit on that and guide that some. And architects and engineers, surveyors, and other land use professionals can participate as witnesses and provide evidence in support of their clients, but they cannot cross-examine, make legal arguments, or examine evidence. So you have the civil engineer here represent, they can't necessarily ask, maybe their attorney does, maybe the applicant themselves does, because the applicant has standing. Civil engineer, I don't see any reason why they couldn't feed questions to be asked, but them asking and doing the cross-examination themselves is not permissible. I would even say that would be staff as well, asking questions of the applicant. I don't know if you agree with that or not, but even though I've seen it happen, but any questions there?
No, that's very clear. Thank you.
And this burden and deliberation, I don't have much to say here, but burden initially starts with the applicant. We touched about that briefly. They have to show, they're going to provide information, and they're going to go through why they believe in a variance, why they comply with the four facts, or a special use permit, how they're going to comply with the four facts. If they've proven that and there's opposition here, then guess what? The burden shifts over to the applicant. Excuse me, to anyone opposed to the case. And the deliberation, we talked about this briefly. All deliberations are in open session. It should be focused on the applicable standards and then based on the evidence in the record. So at the end of the day, here's a couple of sample. We've gone through the process and sample findings of fact. Won't have to read all of these, but the first one is table 3.3 in section 310 of the ordinance. Requires a 50-foot front yard setback in the MR2 zoning district when the structure was constructed. And you saw some of that in the case summary outlined last week or last month as samples there. They're facts that are, they're objectionable facts and not conclusions. Next slide should be some conclusions that are potentially drawn. Well, we will, just based on the information we have, but ultimately, like you saw, the orders that you voted on today, there were some additional ones added, but based on testimony. So the applicant's testimony was X, Y, Z. We wrote it that way to make it clear that this was testimony provided during the hearing. And even then, if there was no conclusions, it was they stated X. They stated that the pool was going to be 10 feet off the property line or whatever it was. And then conclusions there would be the applicant's hardship is self-imposed because he or she knew they should have known that a permit was required prior to construction. That's a conclusion that you would make at the end of the day or end of the hearing. All right, so getting towards the end of this, so our findings and facts and conclusions must be in writing, signed by the chair or an authorized member, explain the logic behind the decision. Typically, they're prepared by staff or the attorney, staff in this case. When we try to get them done as soon as we can, a little bit, they were done obviously before this meeting. And they're approved typically upon signature of the chair. So putting that slide in, we happen to be meeting, a month later. So we went ahead and had you vote on those. But a lot of times, I think you had not met before, February or September of 2023, so it would have been a year in passing. We don't want to call a meeting just for an order to be approved. So the chair has the ability to review the orders and sign them without being inspected by all the board members. Now, chair may want to, hey, here's some feedback or whatever, but we just can't have those orders and decisions lingering for a year or longer. For
30-day window.
Well, the appeal process starts once the order is delivered to the applicant and the property owner. Then they have 30 days once that occurs. So if we mail it, so sign today as an example, and we mail it, the assumption is 3 business days it'll be received. If we mail it today, the assumption is 3 business days it'll be received. Then the 30 days starts from that time.
So for example, if Mr. Elliott, who now has the order in his hand from you, decides he wants to appeal, does the clock start today
Today.
or 3 days from today?
Today, because he has it in his hand.
And you have witnesses.
Mhm. All right. Testimony and evidence considerations. How should non-expert testimony be handled? Ruled on by the chair. Typically, it's heard, but it cannot be the basis of the decision. Standing. How do we determine standing? Ruled on by the chair of the board. It's not staff, so we can't say, sorry, you don't have standing, you can't speak. And likewise, I think it's also we, staff, when I say we, I can't look at an application and say, well, you really shouldn't be applying for this variance. The board's not going to approve you, so we're not going to process it. Dude, you're the check valve. They have due process. So while we may not think it's going to be approved based on our review, we still have to process it and put it in front of you, because we can't just say, well, it's not going to be approved, we're not going to process it. They have that due process right as a property owner in the town of Sunset Beach. And like I said, you're the check valve to make sure that we're doing our job appropriately as well.
Can you render an opinion if you're staff? I
We
mean, if the guy
can.
asks you, hey, do you think this will, do you think I got a chance here? Can you
Yeah.
answer that question?
We can,
Okay.
and we certainly try to guide. And the fence case last month, I provided some based on his request. What is what such and such question? And I said, well, here's some school of government information you could review.
Mhm.
And I think that was part of your record, actually, if you looked at the email. So we can say, here's what hardships mean, and you have to prove all 4 of these. And I'm not sure that your situation, I'm not sure how, based on the information you provided me, how you're showing that hardship. We can have that conversation,
Okay.
but they can still come through the hearings, and then you guys see it differently. And we can provide our opinion, but we can't.
If it was
not
me, I'd
process.
want a soft opinion before I went to the trouble.
Did you want to comment on that? Okay. Sorry, grab your microphones. I wasn't sure. Okay. Okay. And then time limits generally are not permitted. And why is that? So sometimes at a public hearing for a legislative item or rezoning, you got, 50 people here, and the planning board or I don't know if town council does this or not, and say, okay, everybody has 3 minutes to speak. It's a legislative item. A lot of times people are coming up. A lot of times people come in and saying the same thing over and over and over. So legislative decision, again, those would be like a rezoning, text amendment, budget adoption, whatever the case may be. They can put time limits on it per person, or we're going to have 30-minute conversation. But for quasi-judicial cases, we're recommending that it's not permitted, because you don't know when someone may have evidence to present. And if you cut it off at 30 minutes, using an example, and there's still 5 people lined up who want to speak, they may have evidence and new information that you need to consider during your hearing. And so that's why it's for quasi-judicial cases, it's not, we're actually saying it's not permitted. I know you want the meeting to move along, and you probably heard the same thing over and over and over, but you never know what the next person has. Does that make sense?
Yep.
Yeah. Right. So, just a sample hearing process. I won't belabor this, but meetings open, witnesses sworn, presentation by staff, then the applicant. There's potential cross-examination, and rebuttal, objector's rebuttal, summary, and then deliberation and a motion and vote. So I got a couple of questions here just based on. So your board is considering a variance petition. The neighbor appears at the hearing and presents a petition signed by 50 other neighbors opposing the variance. Can you consider that a petition?
No.
And Board cannot consider petition to be evidence. The relevant matters to consider are the facts of the case and whether the request meets the ordinance requirements for variance. In that case, I would say submit it, we'll hand it over. Just don't use it as part of your deliberation. Say, well, 50 people were here to sign this petition, so therefore we should not approve it. Don't use that as the basis.
This is not a popularity contest.
So another question is, your board is considering a variance. It will cost an extra $3,000 in construction to get the driveway in, avoid some wetlands, and still meet the setback requirements. So a setback variance is requested that will reduce those costs to $1,000.
No.
And response there we have is just simply because it will cost money to meet the ordinance requirements is not a hardship. For example, the cost of land could have been reduced by $3,000 to make up for the fact it was going to cost more to develop the property and still comply with the regulatory the requirements.
I have seen where the addition of tax revenue to the town presented as well, and in my opinion, and as it was in that case, that doesn't matter either. Money is not a deciding factor whether it's a plus or a minus. It has no bearing on the case.
Correct. And you would think that any improvement on a piece of property increases the tax value, right?
Mhm.
Because it makes that home more valuable or that property more valuable for what, maybe it's a short term. But
So arguably, the planning board should not have considered the potential tax revenue that would be garnered by annexing the Logan Homes development from their determination as to whether those changes could be approved.
they're not bound by this. They're a legislative and advisory role.
Yep.
So they can consider, and correct me if you disagree, but they can consider anything during their
Or
basis.
nothing.
Okay, because their rules are different than ours.
Correct. They don't have the handcuffs, if you
state.
will, in the deliberations that the Board of Adjustment has.
Okay, thank you for clarifying that.
A different state than what I'm used to.
Different state.
Yes.
Going back to that home rule and Dillon rule earlier. So, that concludes my presentation. I have copies of the presentation for each one of you if you'd like to have it.
I only have one thing to add
Sure.
to your presentation. Great job.
Thank you.
There have been times when cases were coming before the Board of Adjustment that the council might be in a position to object to your ruling. In that case, the town will provide the Board of Adjustment with their own separate attorney. Grady is the town attorney, the town council attorney. So if the town council is going to have a different position than what this board comes out with potentially, you will be provided with your own counsel. I've seen that happen a handful of times.
So if the board has if the council has already made public that they have an opinion on something that's coming to us at the Board of Adjustment, we should automatically have a different attorney because they're going to be represented by the one that they normally are.
It wouldn't necessarily be that the opinion has come from the council to the public. It could be from staff's view of the case that will be coming before the Board of Adjustment, that the council might have a differing view.
I was wondering how you got to that. How would you know?
And, well, because we know the council.
Yeah, well, what I was thinking is, how would we know we needed a different attorney?
Yeah, you won't. Yeah, you
Correct.
won't say to yourselves, "Oh, we're going to need a different attorney from the town
Staff
attorney."
make that call.
Yeah, staff would be able to determine that level.
And I've seen it before. I think I mentioned before. I've worked in Wilmington for 22 years before retiring, but Wilmington sometimes would do it anyway because the question or the issue before the Board of Adjustment was very controversial, and so we had a board attorney who typically was someone, because we had our own city attorney staff, so typically from the city staff. We would also hire an outside attorney to represent staff to make sure, or vice versa, the outside attorney represent the board, and the city attorney staff would represent the city and staff on those matters, just because it could be controversial, and to make sure that both staff and the board were given good guidance without potential conflicts later. I think is what Lisa's trying to say as well. So,
And with everything leaving you and going straight to the Court of Appeals, then that's why it's just, you want to dot all those I's and cross all those T's as you've done today with the orders as well.
Well, that's great, Ron. Thank you very much. This was a very, very good presentation, very helpful. If there any other comment from the board?
No.
Okay, item 6, administrative items. Any additional director or staff comments? Lisa, thank you for your time as well. I'd take a motion to adjourn.
Motion to
Boomer, thank you. Jay, second. I don't believe any discussion is necessary. Let's just call the question. Time to adjourn? Aye? Thank you. All right, everybody, it's good. Kim, thank you so much. For purposes of the